8,000. Remember that number because it is the number that killed a court. 8,000 extra cases a year. That was the promise made to the Australian public when the government decided to abolish the specialist family court and merge it into a general federal court. And where did that number come from? Not from judges, not from decades of court data. It came from a desktop review by the consultancy PwC, a review that took roughly 6 weeks. The Law Council of Australia, the peak body for the entire legal profession, examined that figure and said flatly that it could not be substantiated. It did not matter. The number did its job. 2 acts of parliament later, a 45-year-old institution was gone. This episode is the anatomy of that decision, the story of the merger built on a guess. Let us be clear about what was traded and for what. On one side of the ledger, a standalone specialist family court, created in 1975, staffed by judges who did nothing but family law, with 45 years of accumulated expertise in the most sensitive cases a court can hear. On the other side, a 6-week desktop review produced by consultants claiming 8,000 extra cases a year could be finalised if the courts were merged. When the peak body of the legal profession says the central number cannot be substantiated, you would expect a government to pause. This one did not. The profession opposed it. The evidence did not support it. Parliament passed it anyway. 6 weeks of consultancy work weighed against 45 years of specialist practice. That is the exchange rate this country accepted for its children's court. This is All Kids' Lives Matter, Stolen Generation 2.0. I am your host, David Smith, and this is Episode 5, The Merger Built on a Guess. In this episode, we dissect the biggest structural change in the history of Australian family law, the 2021 abolition of the specialist family court, what was promised, what the evidence actually said, what genuinely improved means that because credit where it is due, some things did, and the backlog that quietly grew anyway, while another jurisdiction devoured the very same judges. As always, everything in this episode comes from public data, the court's own annual reports, parliamentary inquiries, the government's own commissioned research and official responses, and peer-reviewed sources. Nothing is invented, everything is checkable. If you are new here, welcome. We publish a new episode every fortnight, so subscribe and stay with us to the end. Every number you are about to see comes from documents you can read for yourself. The Federal Circuit and Family Court's own annual reports, the Australian Law Reform Commission's Landmark Report 135, and the government's official written response to it, the Law Council of Australia's public statements, the Attorney General's Department's own material on the structural reform, and evidence given to Senate estimates, as reported by the Queensland Law Society. We link every single document in the description. Do not take our word for anything. Check us. That is the entire point of this series. For 45 years, Australia had something most countries envied: a standalone specialist family court. It was created in 1975, and its judges did nothing but family law, children's cases, family violence, parenting disputes, the hardest human decisions in the entire legal system, heard by people who had spent whole careers learning how to hear them. On the 1st of September 2021, that ended. 2 acts of Parliament merged the specialist court into the generalist Federal Circuit Court, creating one combined court over the objections of the peak body of the legal profession. That is according to the Attorney General's Department's own account of the reform. 45 years of institutional expertise in protecting children, restructured on the strength of a number nobody could verify. Here is where it gets truly strange. In its official written response to the Australian Law Reform Commission, published in 2021, the government described the split federal court arrangement, the very structure it was choosing to keep and merge, as a failed experiment, part of a broken split court system. Those are its own words on the record in its own response document. And in that same document, sitting right beside those words, is the government's answer to the Commission's first and central recommendation: not agreed. Think about what that means. The government agreed the system was broken, it agreed the experiment had failed, and then it rejected the fix proposed by its own law reform body and reached instead for the consultant's guess. Because there was another option on the table, and it was not a small one. The Australian Law Reform Commission had just completed the first comprehensive review of the family law system in 43 years. 60 recommendations, years of work, hearings, submissions, evidence. Its central recommendation was the opposite of the merger: abolish the federal family courts entirely and return family law to the states. So one court could handle family law, child protection, and family violence together, the way families actually experience them. That recommendation was marked not agreed. Instead, the government acted in line with the 6-week desktop review. Years of independent evidence from its own Law Reform Commission set aside, 6 weeks of consultancy work enacted into law. Sit with that for a moment, because it tells you exactly how policy gets made when nobody's watching. Now, honesty matters on this channel, so let us give the merger its due, because one part of it genuinely worked. The new court introduced registrar-led triage, senior registrars taking over the early case management that judges used to do themselves. The effect was immediate. According to evidence from Senate estimates reported by the Queensland Law Society, the average judge's docket fell from 330 matters to 193, a cut of 41% achieved within months. That is not spin. That is a real, measurable improvement. And notice where it came from. Not from abolishing a court, from resourcing the front end properly. Remember that distinction because it is the key to this entire episode. And the wins kept coming. For a while. In the court's Division 1, the queue of pending interim applications, the urgent "who does the child live with right now" decisions collapsed from more than 2,100 at the time of the merger to 599, according to the court's own annual reports. That is a fall of more than 70%. And in the first year after the merger, the overall pending caseload fell by 12%, the first sustained backlog reduction in years. So yes, registrars work, triage works. When you put resources into the front door of a court, families get answers faster. The evidence for that is now beyond argument, which makes what happened next on the other side of the ledger so much harder to forgive. Because while the interim queue shrank, the queue that matters most quietly grew. Final orders, the decisions that actually end a case, that settle where a child lives permanently, are the true measure of any family court. In the latest annual report, only 61% of applications for final orders were finalized within 12 months, and the pending pile of final order cases has risen to 15,248, up from 14,394 just 2 years earlier. Read that again. The backlog this merger was sold to fix is growing again by the court's own published figures. More than 15,000 families sitting in the queue waiting for a decision about their children. And nearly 4 in every 10 of them will still be waiting when the case passes the 12-month mark. That is not a statistic. That is a childhood on hold. So why is it growing? Here is the part almost nobody talks about. The merged court's Division 2 judges do not just hear family law, they also hear migration cases, and that jurisdiction is drowning. The court's own snapshot shows 18,266 pending migration applications. Stop and absorb that. The migration pile is now bigger than the entire family law final orders backlog, and in those migration cases, 84% of litigants have no lawyer at all. More than 4 in every 5 people standing alone before a judge. Every hour a Division 2 judge spends on that flood is an hour not spent on a child's case. This is what happens when you pour 2 rivers into one channel. And who is left holding all of this? The court's latest annual report counts 126 judges for the entire country, 35 in Division 1 and 91 in Division 2, supported by 164 registrars. 25 new judicial appointments were made in a single year, and still the Chief Justice's own year in review acknowledged vacancies on the bench. Meanwhile, migration filings surged by 64% in a year. So picture it. 91 Division 2 judges, split between a rising family law backlog and a migration caseload growing faster than governments, can appoint people to hear it. The registrars proved what works. The data proved what works. Nobody scaled it, because scaling it would cost money. And the whole point of the guess, remember, was to save some. So let us return to where we began. 8,000 extra cases a year. That was the number. That was the promise that ended a 45-year-old specialist court. The Law Council said it could not be substantiated, and the years since have been proving them right. The final orders backlog is higher than it was 2 years ago. Judge vacancies persist by the Chief Justice's own acknowledgement, and the same judges are being consumed by a migration surge that nobody modelled when the promise was made. Here is the bitter irony, the genuine improvements. Registrar triage, front-end case management never needed a merger at all. They needed funding. Australia gambled its children's court on a consultant's guess, and by the court's own annual reports, the guess is coming up short, while the families in the queue pay the difference. Here is what you can do, and it takes 5 minutes. First, share this episode. The merger was debated largely out of public view, and sunlight is the correction. Second, contact your federal member of parliament through aph.gov.au and ask one simple, sourced question. The registrar triage model cut judge workloads by 41%. Why has it not been scaled with permanent funding, and when will the bench vacancies be filled? Demand that the resourcing follow what actually worked, not what was promised on a guess. And third, subscribe and turn notifications on. We publish every fortnight. Every document we cited today is linked below, and the next episode is already in production. This system changes when enough of us refuse to look away. A 45-year-old specialist court traded away on a 6-week review whose central number, the profession said, could not be substantiated, and a backlog that is growing again, while the one fix that demonstrably worked goes underscaled. Every annual report, government response, and media release we cited today is linked in the description. Read them for yourself. The children deserve better. The system must change. See you in 2 weeks.